Thank you for joining us today. Please note that there is no CPE attached to this webinar. Please view our upcoming events and webinars at cbh.com for CPE opportunities. Our presentation will begin in a moment.
Good afternoon, everyone. Thank you for joining us on this webinar where we are going to talk more about recent small business administration developments. My name is Bryn McNeil, and I am an audit partner here at Bekaert. Bekaert is a full-service accounting firm where we provide audit, tax, advisory, wealth management services, and one of our key industries that we focus on is government contracting. I am joined by John Carpenter, a principal in our Government Contracting Services Group, as well as Eric Poppy, who is a senior manager in our GovCon group. And Eric, I'll turn it to you to give a little bit of background about more specifics on what you and John work on and kind of specialize on.
Thank you, Brandon. Thank you all for tuning in today. So the Government Contract Services team that John and I are both a part of, we specialize in helping government contractors in any part of the contract life cycle. We like to joke that we hopefully cause our clients to have less gray hairs when working with the government. And our clients are small mom and pop government contractors, all the way up to very large CAS-covered organizations. We've helped nonprofits, for-profits, and everything in between when working with the federal government.
Great. So throughout the webinar, we will take questions, so feel free to submit those. If we run out of time and do not address your question, we are happy to be in touch afterwards, so we certainly will address any concern or question that you have. Also, following the webinar, we will make the slide deck available so you can also have the slides and the content as well. So just to give an introduction on what we will be discussing today. So over the last couple of years, there have been significant statutory and regulatory changes made to the SBA program. So in this webinar specifically, we're going to address several different topics. A few of those will include the proposed changes and how the SBA computes receipts, the interim rule adjusting the monetary size standards, new rules on determining ownership and controls of SDVOSBs, appeals of eligibility for inclusion in the Virginia database of approved VOSBs and SDVOSBs, as well as an update on FAR amendments to the limitation on subcontracting provisions. With that, we'll start out with just talking about some of the basics of the small business computations. And John, I'll turn it to you to kind of go through that initially.
Great. Bryn, thank you very much. Let's start with a little refresher as to how small businesses or how businesses compute whether they qualify as small or not. Recall that in every solicitation the government puts out, they must assign a NAICS code to the solicitation. Probably the topic for another webinar would be to go over how contractors can sometimes influence the government in that NAICS code assignment because it is part art and part science. But irregardless, the government, one of their jobs in formulating a solicitation is to assign a NAICS code to that. Every NAICS code will have either a revenue-based or headcount-based size standard that goes with it. As a general rule, manufacturing-type NAICS codes will be based on headcount. Service solicitations will be based on revenue size. Also, as a refresher, remember revenue size is not calculated based on your GAAP financial statements, but are rather based on tax returns. Thus, a business that is filing tax returns on a cash basis may end up with revenue figures that are potentially significantly different than what's on their financial statements. And recall that headcount-based size standards are measured based on a rolling 12-month headcount, which does include part-timers. Part-timers count the same as full-timers. And over the years, we've seen companies encounter a number of different pitfalls as they weave their way through whether they qualify as small or not. But and among the pitfalls we see include businesses not necessarily understanding what types of revenue flowing through the business have to be measured. Under certain NAICS codes, there are some revenues that may be reported but do not qualify as lifting you higher than you have to be. Certain commissions don't count. We also frequently have to warn clients to not necessarily accept certain parts of work. If you have a prime who's encouraged, if you're in a subcontractor role and you have a prime who's encouraging you to pass through, let's say, a lot of material purchases or equipment purchases at little or no margin, why would you do that if that's going to artificially raise your revenues? And probably most frequently, we just simply see companies failing to really plan properly for the trajectory of revenues they've got, and becoming not small is something that may come as a surprise when in fact some planning could help alleviate that.
There are certainly good reminders and refreshers to have so that companies are making those calculations correctly, and then hopefully will not have anything that is causing them to not be in compliance or to not have the right calculation.
Exactly.
One thing to add is all this can be found at 13 CFR Part 121 if you really want to get into the nuances for those listening of what the definitions are for these certain items we just discussed.
One of the more important pieces of legislation that has impacted how businesses find themselves qualifying as either small or not was the Small Business Runway Extension Act. And on the slide here, you can see the U.S. code reference of where that can be found. As that law was passed, it stated that the administrator, referring to the SBA, could specify how size standards were going to be determined and whether a business qualifies as small or not. Prior to December of 2018, and you can see, how the law was stated, said that basically agencies had to set up size standards, and as we were referencing a few minutes ago, had to set up size standards such that manufacturing concerns were measured based on average employment over a preceding 12 months, and service businesses were measured using annual gross receipts or annual revenues over a period of not less than 3 years. In fact, 3 years is the standard that everybody has been applying prior to 2018. When the Small Business Runway Extension Act went through Congress, the intent was to change that service-based gross receipts measurement from 3 years to 5 years. And that is what the law said when it was passed in December of 2018. Now, many contractors at the time the law was passed, especially those who were in a growth mode, many of those contractors almost immediately said, wow, this is great. Now we can use 5 years instead of 3. And for a time, there was some question as to whether passage of the law immediately allowed contractors to use a 5-year measurement period, or were they still left with a 3-year measurement period? Well, it took about 6 months, but in June of 2019, the SBA went to the Federal Register and said, we intend to implement the change in law, but that's not the same as saying it's effective right away. And indeed, SBA said that the law did not apply to them. It applied to agencies who were looking to perhaps set up their own size standards. But knowing that political pressure would cause SBA at some point to have to comply with the law, they did agree and proposed that they would amend the 3-year period to 5 years. And there were going to be a few other changes to their methodology, but the change from 3 to 5 years has been by far the most sweeping change that they've proposed. Now we highlight The other biggest change was to how SBA is going to treat either acquisitions or divestitures. In the past, if you acquired a business or division, or you sold a business or a division, the revenues, as you were doing a 3-year look back, the revenues were either counted or discarded for the entire 3-year look back period, depending on whether it was an acquisition or a sale. Under what SBA has proposed, they are now looking to require contractors to either count revenues of a sold division up to the date of sale, or not count the revenues of an acquisition until after a sale. And just as an aside, I mean, in the past, we've seen companies, as a strategy for remaining small, we've seen companies divest themselves of a division and remove the divested revenues for the entire look-back period. If this rule becomes final, that strategy basically will not be effective anymore.
So then with these changes, I'm sure that then a lot of contractors were excited about some of these changes. So Eric, do you want to talk through some examples and what some of the excitement about these contractors were?
Yes, so thanks, Bryn. Just as John had mentioned, the Small Business Runway Extension Act, there was a ton of excitement. People wanted to enact a lot of companies wanted to enact the 5-year versus 3-year annual receipt average right away. However, we were in such a kind of limbo that there were rules coming out, and that no one really knew what to do, and we still were in the regular procurement process of trying to go after new work. So there was one protest that we wanted to highlight here that was actually in August 16th of this past summer, that was filed by TechAnnex, which was challenging the terms of an RFP for the GSA OASIS contract, which I'm assuming a lot of our listeners actually might have gone after. So really the quick highlights of this protest was that the law, that was the Extension Act, that was put in place December 17th, 2018. The RFP came out after the fact and did not incorporate these changes within the law. So TechAnnex was challenging that in itself, that the law should apply immediately for the 5-year average when determining small business size. And because the effective date of the Runway Extension Act was before the solicitation, that GSA would be obligated to include in the terms of the solicitation. So what happened, though, was the protest went to GAO, and the GAO actually kind of punted on this. They came back and in short said that it's really SBA's decision to make rulings on the size statutes for federal procurements. And GAO gave the deference to SBA in interpretation of these regulations. So the GAO really just stated that SBA has all the authority under the Small Business Act on incorporating and changing the size standards.
Eric, I'll just add that, probably the short story there is that for all those contractors who, like TechAnnex, who were not going to be deemed small on a 3-year average, but would be deemed small on a 5-year average. And even though one might think that changing the rule from 3 to 5 is a pretty simple change, regrettably for them, GAO really, as you said, punted to SBA, and this seemingly simple change takes yet longer to actually implement.
And even with the proposed rule that was put in place on June 24th, comments weren't due until August 23rd, which was right after when this protest was placed, and we're still waiting on final guidance and a final rule on switching from 3 years to 5 years. So, in summary, SBA commented back that on the protest that GAO referred to them, that they are the ones that get to make the rules, and that they're the ones that have the authority when it comes to establishing the size standards. So now we wanted to talk a little bit about, there also has been adjustments to the size standards. So on July 18th, 2019, there was an interim rule for requests to update the monetary size standards. This is actually statutorily required to change about every 5 years, the size standards. So the revenue standards went up a little bit, and the headcount standards went up as well. This is to reflect changes in industry and other market conditions, and then also adjust for inflation. So again, this came out on July 18th, this past summer. So in this interim rule in July, SBA stated that it's going to review these size standards again in the near future, and that the new standards are actually going to be effective August 19th. So they've been in effect now for about a month and a half. And lastly, these are the standards that contractors should use right now going forward after that date. Further, these are also the size standards that should be used for FAR 52-219 and when you recertify. So additionally, these adjusted size standards should be used when registering in SAM profiles, and also are applicable to FAR Clause 52-219-28 when required. And now John is going to walk through a example for us.
And these are just there's obviously lots of NAICS codes. We just wanted to highlight a few just for those of you who have not had a chance to review the new size standards. Just a few examples of some pretty commonly found NAICS codes. 541330, that's engineering services. The old standard was 15 million. The new one's gone up to 16.5 million. 541512, that's computer systems design, something seen very often. The standard went from 27.5 to 30 million. And then another fairly commonly found size NAICS code, 561210, which is facility support services. That historically had one of the highest size standards out there at 38.5 million, and that's gone up to 41.5 million.
John, can you also speak to some of the practical impacts that some contractors may face because of the revised standards?
We can, and we put together a few numbers here, and this obviously at some point becomes a bit of just a math exercise, and not to walk everyone through too much math, but sometimes a picture is worth 1,000 words. So we just put together two quick examples of a quote-unquote growing company or a shrinking company. And here by example would be a growing company and what some example revenues might look like for a 5-year period, and a shrinking company and what their revenues might look like over a 5-year period. And then here on the next slide, we highlight as an example that growth company who only gets to look back 3 years under the old rule. Well, their average revenues would, in this case, be a little over 15 million. That shrinking company would rather only look back 3 years, and they come up with an average of 20.67 million. But we show you by difference here on the next slide. If they go to that 5-year average, the growth companies are clearly helped. With a 5-year look back, that growth company has average revenues of 11 million. The shrinking companies are hurt by the 5-year look back because their average, rather than being, as we saw, 20 million on the previous slide, now their average is at 25 million. So perhaps everyone understands the impact already, but clearly by going from 3 years to 5 years, growth companies very much helped. The more they're able to keep some low revenue years in the calculation, the longer they stay small. Companies that are small but shrinking are going to have to probably potentially stay out of small business longer until they can get that 5-year average in the range.
Hey, John, we did have a question that pops through here. Can the 3 to 5 year change be applied retrospectively?
It may not. Again, if you're a growth company, you would like to, but no.
Unfortunately,
there's not a retro look back. Correct.
All right. So shifting gears a little bit from what we had been talking about, there has been some revision to the SDVOSB criteria. And John, do you want to walk everyone through some of that for us?
Absolutely. Under the SDVOSB programs, there is, the FAR outlines requirements as applies government-wide, but there are other requirements or potentially other requirements that apply only to the VA. And under the VA program, the VA themselves have the authority to make awards as set-asides, sole source awards, to either verified SDVOSBs, the Service Disabled Veteran-Owned Small Businesses, or just VOSBs, which are veteran-owned small businesses. And here on this next slide, we highlight that really the VAAR, the VA's acquisition regulations, allow them or require that they give priority for award of VA contracts in this order. First, to SDVOSBs. Second, to veteran-owned small businesses, VOSBs. And third, to just other small businesses. The real highlight here in the next slide, the real highlight of the change is that there had been some challenges to VA acquisitions where the VA was working through some type of a government-wide contract vehicle, like a GSA schedule or any other kind of a GWAC. And there had actually been a court case involving a company called Kingdomware, where there were challenges to VA awards. VA was trying to say that task orders under a GWAC did not have to go through this type of priority. And in a court decision, VA was found to not be following their acquisition rules, and the court ruled that VA does have to follow this priority of SDVOSBs first, VOSB second, small business concerns third. And in fact, the VA was also found or instructed that no matter where the agency is in each year on its contracting goals, does not impact the requirements of how they've got to follow their procurements. Now, how businesses become verified as either SDVOSB or VOSB is through a database which is maintained by VA. The eligibility requirements really haven't changed. It's through ownership or control by one or more either veterans or service disabled veterans. Prior to September of 2018, it was the VA who determined who had ownership or control, and their criteria did not necessarily follow SBA criteria. Certainly within our firm, we ran into some examples where businesses thought they met the eligibility criteria, but VA found differently, and which led to a number of disputes. However, following the 2017 NDAA, VA was required, SBA issued regulations defining who owned or controlled, and VA was required to follow those. So SBA issues criteria for determining who owns or controls a concern. The VA has to then determine eligibility. They use the SBA criteria. Companies that are are in a status, companies that want to protest the status of whether they achieve proper ownership or control, those appeals, which used to go through VA, now go through the SBA and go through OHA, their Office of Hearings and Appeals. And I would say that generally, I think most contractors who in the past have dealt with the VA on appeals are probably happier to go through OHA, given the long experience that office has in those type of size determination and eligibility determination matters.
Great. Thanks for that, John. So now shifting gears to kind of our last point of discussion, Eric, why don't you talk through some of the limitations on subcontracting as it relates to the SBA?
Thank you, Bryn. So this update is kind of a long time coming. The Small Business Act back in 2013 was amended back then to permit subcontracts awarded to subcontractors who are similar situated as prime contractors, to be excluded from the calculation of subcontract work. So, to back up real quick, what we're saying here is a lot of times there's a limitation on subcontracting of 51%. So in certain instances where the prime is a small business concern and subs to a similarly situated small business concern, so think of it as an 8A company to another 8A, or a woman-owned small business to another woman-owned small business, that they are excluded from that requirement where that 51% doesn't apply. Well, originally this was put into the Small Business Act in 2013. Then in 2016, to give a little bit of a timeline and history lesson, SBA amended its regulations. Well, then following this past winter in December of 2018, the FAR Council finally got around to issuing a proposed rule amending the FAR to reflect these same changes from the Act in 2013 and the SBA's rules in 2016. At the same time, DoD issued a class deviation, with the FAR essentially adopting the rule. Well, then, one of the final hurdles then, and we're still not complete yet, is this past July, DFAR staff notified the FAR staff that the Defense Acquisition Regulatory Council had agreed to the final FAR rule after the public comment. And now the FAR Council is awaiting comments from the Civilian Agency Acquisition Council. So we just wanted to provide you guys a little bit of an update that, while the FAR has essentially adopted this SBA rule of subbing work from you as the prime to a similarly situated small business concern is practically in effect. We are still waiting to get through the final hurdle of this becoming a final rule and being part of the regulations. Keep acting that way based off that class deviation, but just wanted to give you an update there.
Okay, and we do have one question as it relates to this. So you mentioned about small businesses that are similar in stature. So if a small business, let's say woman-owned prime, issues a subcontract to another small business that's also woman-owned, where do the 1099 independent contractors fit into that?
So this is a gray area still, sadly. The SBA has not weighed in on that, and so right now they are not covered in that exclusion.
Well, thank you all for joining us today, and if you do have any further questions, we've included all of our contact information for myself and John as well as Eric, so feel free to reach out if you have anything additional, and then we will make the slide deck available to you as well.